silencer here. All right, welcome to our first NIJC Pro Bono webinar series, Telling Your Client's Story, Affidavit Writing 101. Today we're going to talk about how to write an affidavit primarily in the asylum context, but also in other immigration contexts as well. My name is Ashley.
The broadcast is now starting. All attendees are in listen-only mode.
Welcome to NIJC's first Pro Bono webinar of our Pro Bono webinar series, Telling Your Client's Story, Affidavit Writing 101. Today we're going to be talking about how to prepare an affidavit primarily for asylum cases, but for other types of immigration matters as well. My name is Ashley Huebner. I'm a managing attorney in the Asylum Project at the National Immigrant Justice Center, and along with my colleague Karen Zwick, a managing attorney in NIJC's LGBT Immigrant Rights Initiative. We're going to talk about some background for writing an affidavit primarily in asylum cases, and then the nuts and bolts of actually preparing an asylum case, preparing an affidavit for an asylum case and getting it ready for filing. If you have any questions, please type them into the chat portion of the webinar software, and we will answer your questions towards the end. This webinar will be available as well on our website shortly after today. So a very brief overview about NIJC. Most of you who are listening to this webinar probably are familiar with us already and have a case with us. But NIJC is a nonprofit legal services organization for low-income immigrants in Illinois, Wisconsin, and Indiana. We provide both direct immigration services and we do national impact litigation and advocacy work. We rely heavily on the information we learn from our direct service work to further those advocacy and litigation goals. And we also rely heavily on a pro bono network. Particularly in our asylum matters, but also in some of our other immigration matters as well. We work with a network of approximately 1,500 pro bono attorneys. And if you're participating in the webinar today and do not yet have a case with NIJC, we encourage you to contact us and discuss about getting involved. There's contact information at the end of the webinar about how you do so. All right, so we're going to talk first about Affidavit Basics and sort of what is the role that an affidavit plays and the purpose of an affidavit, again, primarily in an asylum context. So one of the first reasons that you prepare an affidavit in an asylum case is to establish that your client is a compelling person, a human being, not just a name on an application, and that your client has a compelling basis for relief. So what's really crucial here in your affidavit, and Karen will talk a little bit more about this in her section, is to use your client's own words. You want the reader of the affidavit, whether it be an asylum officer, an immigration officer, or an immigration judge, to really get a sense of who your client is, your client's personality and your client's background, which means using words that are appropriate for your client's education level, your client's age, your client's socioeconomic status, and other things. The affidavit should not sound like it was written by an attorney. It will be much more compelling if it sounds like it was written by your client. And another way to do that is to include information about emotion, which we'll be talking about later. But really one of the main reasons for this affidavit is to really establish who your client is, not just to their claim, but as a person. A second reason that you prepare an affidavit is to establish your client's eligibility for relief. And this is where there's a real difference in when you prepare affidavits in other contexts. Often we get questions from attorneys who are used to preparing affidavits for use in other trial proceedings, and they say, you know, I want to keep my affidavit really short. I don't want to include a lot of detail because I don't want to tie my client down to any specifics. And although there are some reasons when you want to avoid using certain types of detail in your affidavit for that reason, in an asylum case in particular, you really do need to include all the information regarding your client's asylum claim in the affidavit. So this means addressing all of the elements of the claim. So describing your client's past persecution, who was a persecutor, why that persecutor can't be or will not be controlled by the government if it wasn't a government entity, the nexus or on account of reasons, the protected grounds, and why your client could not safely or reasonably relocate within their own country. Of course, discussing all of these things within your client's own words and not using those specific legal terms of art. One of the main reasons you do this is because no matter whether your client is seeking asylum before the asylum office or the immigration court, the attorney often has very limited control over how much information is going to get out during a hearing or an interview. And so by including all of that information, you're both ensuring that the adjudicator can see the full details of the claim, but also you're ensuring that you are preserving and making a strong record to support your client's claim for relief. And then finally, as sort of mentioned in the first point, the basis for including and preparing an asylum affidavit is to establish your client's credibility and the plausibility of the claim. If you have reviewed NIJC's asylum training, you know that credibility is one of the most important components of an asylum claim. It is really what makes or breaks the case. And the client's affidavit is the main way that you establish your client's credibility. So in most cases, whether before the asylum office or the immigration courts, the adjudicator will be reviewing the affidavit as your client is testifying and comparing the affidavit to your client's testimony. So if there are significant details that are mentioned during your client's testimony but not in the affidavit, that could be an issue for the adjudicator and will make the adjudicator question your client's credibility. So it's very important that testimony and affidavit be consistent, but also that you include sufficient details in your affidavit to make your client seem credible and to make the claim be plausible. Now, there are reasons why you don't want to include too many details in certain situations, and Karen will talk more about that in a bit. So once you have a client and you're preparing for your first meeting with your client to prepare an affidavit, there are a number of different things that we recommend you do. The first is to review the intake notes in the case file that you had from NIJC. You may have reviewed them already, but take another look before your client meeting. But keep a couple things in mind. So when NIJC does an intake interview with a client, it's typically a 1 to 2 hour meeting. It's usually the first time we've met with the client. Sometimes it's the first time the client has spoken with anybody about why they came to the United States. So although we try to get as much information out of that interview as possible, it's impossible to get everything out. And we're also working with an individual who may not trust us yet, who may not be comfortable sharing a lot of information. And because of the short nature of the interview, the possibilities of misunderstandings and miscommunications are high. So you may want to prepare an outline based on the notes in the case file for how you think the affidavit will proceed. But we would be very careful and really encourage you to be careful not to assume any facts and to really go into the first affidavit meeting with nothing set in stone as to what happened in your client's case and not to assume anything. We found sometimes when pro bono attorneys ask questions based on facts included in the case notes, certain information will be lost because they will assume that something did or did not happen that was not really clear in the initial intake notes. We also recommend that you familiarize yourself with the relevant country conditions in your client's country, and this is primarily for two reasons. First of all, it's going to save you significant time, especially if you don't know much about the country before you took on your client's asylum case. A lot of our clients come from countries with very complex histories and political situations, and you don't want to spend significant time in your affidavit meetings trying to understand the historical or political significance of particular events or particular groups, especially if you have a client who's not able to explain them very well or may not fully understand that history themselves. So if you familiarize yourself with those country conditions ahead of time, that will save a lot of time in your meeting. The other reason to do so is it's going to be very helpful in developing rapport with your clients. A lot of our clients will come into meetings, and if the attorney is already familiar with who the prime minister is in the country or who the ruling party is in the country or who the major opposition groups are or why there is civil strife occurring in a particular region, that's going to go a long way to ensuring that the client both trusts you and also believes that you are going to be a strong advocate in their case. If you come in not knowing anything about the country, the client might be offended, the client might feel like you're not taking the time to prepare for the case, and so that can set things off on a bad footing. And then finally, we would encourage you to establish a roadmap for yourself about what you would like to accomplish in that first affidavit meeting and in subsequent affidavit meetings as well. And again, this has two purposes. One is to save your own time, to make sure that you're moving ahead efficiently, especially understanding that much of the information you get for your client may be complicated. And if you have a roadmap, it's going to ensure that you're getting information out in an efficient manner. But the other thing to keep in mind is to have efficient meetings with your clients. A lot of our clients have limited time that they can spend meeting with their attorneys because they have numerous other obligations. They may have traveled multiple hours to get to your office. They may have had to pay somebody else to give them a ride to come to your office. And you want to make sure that they're using their time as efficiently as possible. So when you have that first client meeting, what are some things that you want to keep in mind? One of the first things that we recommend doing, and you often may want to do this in subsequent meetings as well, is to explain to your client why they need to talk about what happened, why they need to talk about why they're applying for asylum, why they need to talk about the things that happened in their home country again. Because by the time a client comes to you, they may have already explained their fear of return to an immigration officer at the border. If they were detained, they might have met with another legal service provider at their detention center or at the shelter if they were an unaccompanied child and explained things to them. Then they came to NIJC and told us what they went through. They may have also been referred to a counseling service and told the counselor what they have been through. And by the time they get to you, they may not want to talk about what happened to them again. They may be frustrated about the fact that they've now had to repeat themselves multiple times. So it's going to be extremely important that you explain why it's so crucial that they talk to you. And though you have information from us about their case and you know general information, you need to hear from them firsthand about why they need to seek asylum here. In addition, if you explain exactly what they need to tell you about for their asylum case, so you explain what asylum means, you explain what you have to prove to get asylum, they're going to be much better active participants in your case preparation and will be much better to cooperate moving forward in the case. You also want to make sure you reiterate confidentiality, and I don't think you can emphasize this enough. Every single meeting, it's important to reiterate what confidentiality is. Many of your clients may not understand the term confidentiality, so you're going to need to be creative in explaining what that means. But making sure they understand that what you tell them is not going to be told to anyone else, specifically their government, their persecutor, potentially family members or others. And then it's also important to empower your clients throughout the process, both during their meetings with you and during their asylum interviews or immigration court hearings, to say, I don't know or I don't understand. Throughout the course of our representation of clients, we've seen numerous instances in which cases went south because a client felt pressured to give an answer to something that he or she did not know. And so it's really important that the clients understand it's better to state that they don't know or they don't understand rather to guess at an answer. When you start your affidavit prep, one of the common questions is how do you begin? Should you start talking about background in the client's country first? Should you start talking about their claims first? And this really depends on how you want to proceed in the case and what the facts are in the particular case. I think there's a lot of types of cases where it can be very useful to try to get a sense of the client's upbringing and background, especially in a country that may have had a very volatile political history, to get a sense of where the client stood and where the client's family stood in light of that political history. But in other cases, if it's not a very complicated past and it really relates to your client's specific situation. For example, maybe in a case involving child abuse, you don't really need to have a discussion about what the political situation is in the country and the historical situation in the country, and you can really focus on what the client's home life was like and what led to the child abuse that led to the client fleeing and coming to the United States. And then finally, one thing that is also important to do throughout your case representation is to always check in regularly with your client to make sure you and your client are on the same page regarding the definitions that you are using. It's very common for a client to use a word and for you to use a word as the attorney that mean completely different things. So one example would be if a client says, I'm bisexual. You'd want to follow up with the client and ask them what they mean when they say bisexual, because it may be a term that they've used when they really mean to say that they're gay, but because of a particular situation in their country and the stigma and discrimination and persecution against gay people, that they typically say bisexual to sort of cover up that particular situation. Another example we commonly see is when we're talking to children and talking about how they've faced harm related to refusing recruitment by gangs. They'll often say that the gangs bothered me, which is very much typically downplaying what actually happened with the gang. So asking follow-up questions, what does it mean when you said the gang bothered you? What do you mean by bothered? Another example would be in the context of domestic violence or gender violence cases. We often see women who talk about their relationship with their partner and say, he wanted to have sex with me all the time. And it's important to follow up and say, you know, what does that mean? You know, when he wanted to have sex, did you have sex? Did he force you to have sex? Did you want to have sex with him? A lot of our clients are not comfortable or used to using the word rape to describe a forced sexual relationship in the context of a marriage or a partnership. And so really making sure you're following up on those definitions and making sure that you're on the same page. So a few other things to keep in mind during your affidavit meetings. One is to use affidavit preparation to check on client credibility, and I think this is something that attorneys don't always think about, because you think about using your meeting to prepare the affidavit that you're going to be submitting and only wanting to ask questions that directly relates to the affidavit you want to submit. However, there's a lot of things you may want to ask questions about just to make sure your client is able to give a credible and plausible answer, even though ultimately you don't think you're going to include that information in the affidavit. So for example, when I have a client who was imprisoned in another country, I may not want to include a detailed description of what that prison was like in my affidavit, because there may be no reason to do so. I may not want to tie the client down to that information, but I want to make sure that if the client is asked, the client is able to give a description of her jail cell that both is consistent and makes sense and doesn't raise any kind of red flags or raise any kind of confusion. So I may ask my client what the jail cell looked like, if it had windows, if it had a light, how big it was, and whether there were bars, because keeping in mind that certain things like that, the adjudicator may have certain assumptions. So an adjudicator may assume a jail looks a certain way. If your client was in a jail cell that did not look a certain way, you want to make sure you have a good answer to that and your client has a good answer to that, even if you're not ultimately going to include that information in your affidavit. Typically, you're going to want to work from easy issues to the difficult ones. You usually are not going to want to ask your client specific questions about the details of the torture or persecution he or she suffered in the first couple of meetings. Sometimes you have to do so because you have a very quick case and have to move quickly. You may have a detained client and you don't have much time to really develop rapport. But generally speaking, that's not something you want to start out with. It's better to start out talking about background, biographical information, job history, employment history, educational history, and those sorts of things before getting into the detailed bits of information. It's important to keep in mind that attorney discomfort creates client discomfort. So if there are particular questions you need to ask your client about that you're not really comfortable asking about because they're not the type of questions you would normally ask anybody in any situation, your client is going to catch on to that and be uncomfortable as well. And that can have a variety of consequences. So for example, if you have a client who suffered gender violence, let's say female genital mutilation, and you aren't really comfortable asking about the details of how that impacts her day-to-day life, your client is not going to feel very comfortable talking about it. And that can be problematic both because you want your client to feel open with you and to really feel like your client can share information with you so that you have all the details, but you also want your client not to feel any shame associated with that particular situation. So the same would be in a case involving sexual orientation. You need to ask your client questions about their coming out and about past relationships that you may not be very comfortable asking. And if you demonstrate that discomfort, your client is likely to feel uncomfortable and not want to talk about it either, which can be particularly harmful when your client is seeking asylum because he or she is not able to be out regarding their sexual orientation in their home country. And then finally, one of the common questions we get from pro bono attorneys is, my client just told me something that's completely inconsistent with the intake notes you sent me, or is completely inconsistent to what I know actually happens in a particular country. What do I do about it? And our first response always is talk to the client and ask the client for an answer. It's very important to confront clients regarding these inconsistencies and implausibilities. Often there are very reasonable explanations, but you need to get your client's explanation first before trying to figure out how to fix an issue, how to potentially present a perceived implausibility or inconsistency before an adjudicator and deal with it in the future. It's of course really important to do this in a reassuring and non-confrontational way, but you do need to offer your client the opportunity to explain what appears to be an inconsistency or an implausibility in their case. And then finally, getting started in that first meeting. So during the first meeting, it's typically going to be a situation where the client will be providing a narrative. Most of the time, you're not going to want to do a lot of rapid-fire back-and-forth questioning in that first meeting. You want to offer your clients an opportunity just to talk about why they came here and talk about their history, and then add a little bit of follow-up notes as need be. So often, I will start a first meeting by saying, what was it like growing up in your country? Or what was your family life like? Or how many siblings do you have? Where did you go to school? And start there to just start a narrative going. You're going to want to take as many notes as possible. Typically what I'll do is just take literally verbatim notes throughout the whole meeting and then start working it into an affidavit later, but with the focus of the meeting just being able to get as much information down as I can so that subsequent meetings can include follow-ups and getting additional details. I do always like to make note of specific phrases that I think are particularly powerful or that really provide some emotional insight into the client. So, for example, if a client says to me, you know, my husband always beat me because in our country that's what husbands are able to do to their wives, that might be a really particularly powerful statement from the client about why she was being persecuted. And whether I decide to include that specific quote, I may want to paraphrase that statement in an affidavit because it provides a really strong statement of nexus from the client. Emotion is really crucial, and I think including emotion is something that doesn't come naturally to a lot of attorneys because they don't think about including emotion into a legal affidavit. But in asylum cases, it can be really important to establish credibility, establish plausibility, and to really, again, establish that your client has a compelling case and is a human being who needs asylum. So that's some basics about preparing for creating your affidavit, and now I'm going to turn things over to Karen, who will talk about affidavit execution.
Hi, everybody. Again, I'm Karen. I am a managing attorney here at NIJC too. So Ashley just talked about some of the meetings and sort of the lead up, and now we're going to turn to how to sort of translate that information into the actual written document. So I've divided this section into a few steps. You don't need to follow these steps exactly, obviously, but there's just sort of a guide of what we like to do and how things seem to work out the best for us. On the slide that you see right now, you'll see on the right of the slide a sample version of an affidavit. This is just like the first page, just so you can see the basic structure. I think that for a lot of people who are writing, seeing a blank Word document can be an impediment to getting started. So seeing something like this is just to give you an idea of what your sort of format is going to look like. You can also go to NIJC's website. We have many samples. They don't all look exactly like this. You don't need to follow this exact format verbatim, but there's lots of samples there that will show you the various things that you need to do. A few things that sort of you do need to do on every one is you definitely want to lead off with some information about who you're talking to. So if your case is in immigration court versus the asylum office, lead off with that. You also, of course, need to promise at the beginning and then again at the end that what your client is saying is true and that they're swearing under penalty of perjury that it is true. And then use numbered paragraphs. Try not to keep your paragraphs too long because you don't want them to be easy to read for the asylum officer or the immigration judge who is not going to be able to spend quite a lot of time with this document. Okay, so then once you get to the meat of things, generally speaking, we recommend going in chronological order, and we'll talk a little bit more about what that means over the next couple of slides. But you definitely want to start off with some kind of introduction, even though you are initially and eventually going to get into a chronological order. In other words, what I mean is you want to say, ideally on page 1, like this is the basis of this claim, so that when you turn the page and start going through the story, the reader knows why you're going where you're going. And then the other thing that we strongly recommend is short interior headings, not like argumentative headings, but things like my decision to flee the United States, my decision to flee to the United States, or my joining X political group, or coming to terms with my sexual orientation, things like that, because those kinds of headings just will help the reader follow along and keep track of where you're going. And from a writing perspective, they will help you organize your thoughts. If you know that you have a few sort of themes that you need to cover, when you take your long notes that you've made from your meetings with the client and begin putting them into sections, having those sections identified before you start will help you sort of categorize topics. Okay. So on the chronological order point, the first question often that we get is, where do you start? And the answer, of course, is it depends. It depends on your client's story and where the client's story begins. Like Ashley said, the goal for you is to get your reader to understand who your client is and to feel compelled by them and understand why he or she is here in the United States. So, for example, if you have a client who became a political activist in his 20s, you might not spend a lot of time talking about that client's youth and upbringing. Where by contrast, if you have a transgender client, you might need to talk about their early childhood and when they first began to understand their gender identity in a way that you might not. So in those two examples, one contrasted with the other, the story for the man from Zimbabwe would start potentially quite a lot later than the woman from Honduras. And the same goes for a case like involving a woman, a domestic violence situation. In those kinds of cases, you might not need to talk about the childhood, but you might need to talk about the childhood, because if a client is somebody who left a domestic abuse situation as a child and married into a house where they were abused again by a partner, that's going to be relevant to their overall state of mind and to their future fears. Okay, and then comes the question, of course, of where do you end? This is a little easier, I think, than figuring out where to start, because everybody's case story ends somewhere in the United States. You need to get your client's story all the way through why they came to the United States and what their life has been like here. How much detail you include about what's been going on for them in the United States really depends on how long they've been here and what kind of case it is. For example, if your client is somebody who has a one-year filing deadline issue, you obviously are going to need to talk about the factors that go into that in this interaction part of it. So things that but the long and the short of it, there are a few things at the bottom of the slide that are things that you want to cover. For example, does your client fear the exact same people who harmed them in the past, or is it the fear more future looking? And if that's the case, you definitely want to sort of explain not just what happened in the past and leave it off there, but what they fear going forward. And that's a really important thing to keep in mind, and I think it's a little bit counterintuitive for asylum cases, is that really an asylum case is about proving your fear of future persecution. We're very focused on past persecution because that is one of the key ways to establishing a presumption of future persecution, but if your client is no longer afraid, then they will not win despite their past persecution. So you have to sort of link their past harm to what they fear going forward. And so these themes at the bottom of the page are sort of aimed at getting to that. If someone had experienced harm quite a long time ago, why do they still fear that same harm? If it was by only one person, why do they fear that same person? How do they know that person is going to find them? Do they fear other people? In other words, the long and the short of it is make sure that you don't discount the need to talk about what your client fears in the future, even if it might only be tangentially related or even somewhat different than what they experienced in the past. So for example, with a lot of our sexual orientation-based cases, we might have a past persecution based on someone being molested as a child by an uncle or an aunt or something like that. And that they might not really fear that person now that they're an adult, but that doesn't mean that they don't still have a fear of their community in general and of homophobia in their country more broadly. So you have to talk about not just the past harm, but also what they're afraid of going forward.
And I would just add that I think of all the affidavits we review, I think we very often see very strong past persecution descriptions in affidavits, but a very common issue we see is a failure to address the future fear arguments. So definitely something to keep in mind.
Yes. Okay, so going to the next theme of what to talk about with respect to things in the United States, as I've already sort of alluded to, the one-year filing deadline is something that if it's an issue in your case, you certainly have to explain it. If your client's life has changed in such a way that in the United States that it creates a new risk for them going back, you need to cover that. For example, marrying a same-sex partner, converting to a different religion, getting a divorce if you're from a country where divorce is not allowed, those kinds of things. A lot of asylum seekers do not have, most asylum seekers do not have criminal records, but there will be some times where your client might have had interactions with the United States legal criminal justice system. If that is the case, those are the kinds of situations where you want to get your clients information about them. This is the sort of situation where if it happens, I strongly urge you to contact NIJC before deciding one way or another to put that in your affidavit, because it might not come up, or it might come up and you just have to decide. It's about how to balance the sort of possible negatives that would come from putting something like that in versus the need to prove to the judge or the asylum officer that your client merits a favorable exercise of discretion. And the same thing goes for things like what's happened with corroborating evidence, and if your client has had previous encounters with immigration officials, like for example, a credible fear interview or a border interview. Often, I would say almost always, there is something wrong with those initial interviews. Those are the kinds of things that we really don't want you to take inconsistencies with those documents as signs that your client might be not telling the truth, because those interviews are extremely unreliable. So I think that it's very important for you, if you have a client who had a credible fear interview or a border interview or both of those, to review those documents with your client, talk to them about them, talk to them about who the person was who gave the interview, how long it lasted, how careful they were, what language they were speaking. There's not always a translator in those interviews. And just make sure that you just sort of front, head on. If there's a problem with that interview, for example, I've had a client where they said, I was afraid of my cousin when really he was afraid of his uncle, and it was just a mistranslation issue. And those kinds of things, if you don't confront them, they can totally destroy your client's credibility. But if you do confront them head on, they generally can go away.
And there's very clear Seventh Circuit case law on the factors that can make one of these initial interviews unreliable. And so often you want to look at those factors and then address each of them in your affidavit.
Okay, so then the next step is editing. So just in a practical manner speaking, probably what you've done is you've sort of gathered up all of your notes, and you sort of started putting them into buckets of like topics and themes, and you can type things out, and then you're going to put in little comment bubbles or whatever method you use to say, I need to get more detail about X, or should I really include Y? And you want to be asking yourself those questions. But then also along those lines, there are a few sort of important steps that you want to take with respect to your client too. As Ashley was saying, it's extremely important that you use your client's voice and avoid using legalese. Your brief is the time for you to say, your brief or your letter to the asylum office is your moment to use your fancy legal vocabulary and your education. The client's affidavit is an opportunity for the client to tell his or her story. And maybe you have a client who is extremely well educated and does have a very sophisticated vocabulary. Don't be afraid to use it in that context. But if you don't have that, just be cognizant of that also. So ask yourself consistently, are you using words that your client would never say? And if that's true, then really revisit whether or not that's what you're saying is appropriate. And then the next rule I would say is you want to be careful about balancing the level of detail. Generally speaking, we always advise you to avoid precise dates and numbers because they're notoriously hard to remember. Even if they're really important to you, like you might, if you think about your own life, you might not remember the exact date that your grandparent died, but you might remember what season it was in or something like that. And those are the kinds of things where if you tie your client down to a date and they rattle off a different date even by like a day or two in an interview, that can create an inconsistency for a client that is totally unintentional. And it's also totally unimportant, frankly. So just put generalized information, several, a few, many. Those kinds of words are much more useful, and seasons. And for the key events, your goal, and when I mean key events, I think that what I'm talking about is like the main instances of persecution that a client might have experienced. Your goal is to create a scene on paper that allows the judge to visualize what you're talking about. So Ashley mentioned it, in her presentation about asking a client about the jail and how they got away. I think it's extremely important to get those details, and I even would say that it's extremely important to even write them out, even if you don't ultimately end up including them, because I think it's really a good way to test your client's story and sort of see how it's going to read to the judge. And just remember that you need to be skeptical, not just. You need to be skeptical. Your goal is not to just trust your client blindly, but to sort of push the bounds of what they say, not in a distrustful way, but in just recognizing that there's going to be somebody else who's going to be doing that to them, and so that you can protect them from that kind of skepticism down the road. And then the last thing I'll say about balancing the level of detail, if you have a client who has been persecuted over and over and over again, and it's a kind of situation where they might not be able to sort of disaggregate which time was which, or there's just too many sort of instances to include. You might just say we're going to focus on a few and then pick out the ones that are the most serious. But if you do that, it's really important to say that these are just examples, and you put in some of that language, because if you don't do that, and you're saying you're in immigration court and the client brings up another story that's not one of the ones that you included, the judge might say, well, why didn't you put that in your affidavit? And the answer is, well, because my affidavit was already 12 pages long and I didn't want it to be 30 pages long and we couldn't put every single thing in there. But you want to make sure that you insulate your client from that kind of scrutiny from the judge. On that point, I think the other thing I will say about that is it's been my experience that if clients do have quite a lot of persecution, sometimes it's very difficult for them to remember which thing goes with which instance. So if you have a client who's been like beaten up by the police on 10 different occasions in their country because they're transgender, they might not remember which time was the time when they were beaten with a baseball bat versus a, you know, having like molested or something like that. They just might not be able to sort of separate those out. And though we really do want to urge you to be chronological where you can, those are certain situations where being vague, or not vague, but just sort of including the details but not sort of tying them down to a specific date and time incident is really important. Okay, so next thing about the editing process, make sure that you, this is something that I think is sort of a basic writing tip that I think is often easy to forget. Make sure that you introduce themes and characters as they come up. So for example, I often am reading someone's affidavit or editing somebody's, even a brief, and they introduce a character, but they have never told me who that person is, or who the they is, or the why something is happening. So make sure that you provide that context. And importantly, in an affidavit, if you introduce a bunch of characters on page 1 and then one of them doesn't come up again until page 6, you might want to remind the reader who that person is, because otherwise you're just inviting confusion. And the goal, again, here is to make sure that the adjudicator can read this affidavit and get a good sense of what your client is all about. And also, just in general, you want to consider how does the theme of this paragraph or this numbered section relate to what's going on in the previous one and the following one. And if you're trying to tell a story in real life, you're going to use phrases like, and then this happened, or after this. You tell a story in a sort of way that makes the listener to your story engaged and following along what's going on. Ask yourself those same questions as you're writing, and if you haven't communicated sort of how one thing is related to the next, think about ways to do that. And then finally, I just want to emphasize that all of the things that you're going to be producing for your case are linked together. That includes your client's affidavit. This is a webinar about client affidavits, but I really just want to make sure that you know that you should not be considering your client's affidavit in isolation. It needs to go with whatever you say in your brief, and it needs to be consistent with all of the corroborating evidence that you provide. And you're going to want to link all of those three things together. So even though we consider the affidavit to be the most important document that you're going to work on and the one that you will spend the most time with, you have to sort of do it as you go with the other things, and you're going to need to finalize everything all at once. Okay, last step of this process, I think. So then the next step is reviewing and finalizing your materials. Just some nuts and bolts. Obviously, your client needs to sign it. If your client is a non-English speaker, you have to have a certificate of translation saying that somebody either read or provided a written or oral translation of the document to the client. The original signature should go to the asylum office or the judge. And if the client is not detained, and you can actually do so, you should always endeavor to have your client's documents notarized, just for veracity's sake. And then when it comes to before, like in the process of leading up to that, you want to read your affidavit to your client. This is the kind of thing that I feel like every time I do it, I feel like it's going to take one meeting and it takes 3 meetings, because there's like a little something that comes up or something that I'm like, oh, that's not exactly right, and we have to redo it. And so just don't wait till the very last minute to do this review with your client, because it definitely is much more complicated than it seems like it should be. And then this is something that I think is also hard. This is something I've learned along the way. If you finish your client's affidavit and then you're writing your brief and you're like, oh, I really want my client to say this thing about nexus, and which is totally true, I just forgot about putting it in my affidavit, you need to be able to go back to your affidavit and make those kinds of modifications so that you can have your client testifying on paper about the things that are important to the elements of the case. Can you read that?
There's a question from the audience. The question is, do you ever have the client do the first draft of the affidavit and then have the attorney edit? or is it better to have the attorney prepare the initial draft?
So that's a great question. Our answer to that is that we do not like for the clients to write their affidavits themselves. If they want to write something out, that's totally fine and appropriate, but that cannot be, we don't think that that is the affidavit. Your goal is to take whatever they write in that and put it into the right format and develop it and ask them questions and push back and have those conversations, because if you write it, if you write that, allow them to write that and say, okay, here's your affidavit, then the temptation is to not push and not dig into some of these issues. And also, your client is not going to know all of the things that are relevant. And they're going to write down things, and they're going to be like, here's my whole story, and then you're going to be like, well, why didn't you tell me this? And they're like, I don't know the answer. I didn't think that that mattered. So you have to be really mindful about that.
Yeah, we would strongly discourage people from having their client take the first stab at the affidavit. I think it generally is a recipe for disaster, even with the most educated clients, because they just simply don't know what's relevant and what's crucial and what really needs to be included in the affidavit.
Okay, so at the bottom of the slide, there are some common questions about affidavits. Number one, should I translate my client's affidavit? If you have the resources to do that, I think it's a pretty good idea. It sort of insulates you from making sure that your client is really understanding. You want your client to really understand very well what's in the affidavit, and it might be actually more time efficient than you having to read it to them over and over and over again. I will confess that we at NIJC do not always do that because we don't internally have the resources to do so, but if you can, I think it's a good idea. Should I give my client a copy of her affidavit? This one is a little tricky because I think that it's their statement and their words, and you sort of have to give it to them if they really want it, but you have to do so with a caveat that they really can't memorize it, and if they do memorize it, they're really shooting themselves in the foot. And I have had many situations where I have had clients, when I used to give out the affidavit sort of as a matter of course, and I've had clients memorize it, and they sound like a robot if you do that. So it's really important for you to make sure that if you do give it, you give it with a strong warning not to do that. And then the last question, and this is something I think attorneys really struggle with. If your client is detained, what do you do about the signature and this review process, because everything is happening fast and you're often doing it over the phone? To be real, in the detained context, a lot of things happen. The cases, you just have no choice but to prepare the cases in a way that is not as ideal as you might like. So oftentimes what we do is we send a blank signature page, so like without any text on it, on a standalone page to the jail, even before we're done with the affidavit, and we have the client sign it and send it back, even though we know that the affidavit is not complete, and then we review the affidavit over the phone and say, with their oral permission, the signature that you have given us, we are going to attach to this document, and that's how we do it. And the reason is because you need a signature, and it takes time, and you often don't have time to sort of go through the process of going back and forth by mail and phone with detained individuals to get this information. Okay.
So we're going to really run through very quickly some ethical issues that can often come up in affidavit preparation. And so one of the first things that often comes up that we hear from attorneys is, what if you have a client who is reluctant to talk about certain things or doesn't have information that is true from other witnesses or other sources, and how do you include that if your client can't necessarily articulate that same information? This comes up in a wide range of contexts. I think this comes up a lot when working with children who may not have the full understanding of why something happened to them that maybe their parent knows. This can happen sometimes with a client who maybe doesn't have a full grasp of certain historical incidents in their country, or maybe just confuses the history. So the client thinks that a crucial election happened on this particular date, but from country condition records that it actually occurred on a different date. And I think the answer to all of this is if you have information that is true, but your client cannot articulate in some ways, you're likely going to want to submit that information anyways as part of the case file. And so your client has a right and needs to know what's in the case file. Your client will be asked at the interview or the hearing if they know what was submitted on their behalf. But you want to be able to address it in your affidavit as well. And so what I think I typically do in a lot of cases is I will present that information to the client and say, your mother told me that this is why your father had to flee the country. Did you know this? And if the client didn't know this, you can say, okay, well, why don't you talk to your mother about that, or what do you think about that, or is that consistent with what you understand? Or, for example, if a client says, you know, I was arrested after this election that occurred on February 1st, and you know from news reports the election occurred on January 1st, you can say, okay, well, I understand you think it occurred on February 1st, but I pulled up this news article that says it actually occurred on January 1st. Do you think that might be the case? And you can address that information then in the affidavit in that way. So, for example, the client could say, well, I remember something happening in February. My attorney has told me the election occurred on this date, and that does seem to be accurate. If you think your client's not going to testify consistently to that, or if your client doesn't really know about his father's involvement in a political opposition group, but his mother told him about that, he can say, I don't know much about this. My mother has told me my father was part of this political group. This is what I know, and this is why I know it. And just explain things in that way. It's very important that your client know the information that's going to be included in the package you're filing on his or her behalf, but if he doesn't have firsthand knowledge of that information, it's important that you explain that in the affidavit as well.
And also that you just fact check. You use this as an opportunity to fact check. We have a case where a client was told by their family in Mexico that they were kidnapped by a certain gang that actually did not exist at the time of the kidnapping, but and it's actually totally a very easily understandable thing because the client has been living in the United States, and he actually doesn't know that gang X is now gang Y, and they were using the gang X name when really it was the gang Y name, and it's totally fine. But it's the kind of thing that if you can't go through and fact check all of those things, you can really have a bad situation in court. Okay, so then the next one is, how do I deal with inconsistencies? So like that example, for example, is a good one. So what do I do if my client has not given me a consistent account? Or if my client seems to be forgetting things, or if a witness has provided me contradictory information? Obviously, the rule number one is have a conversation with your client about all of these things, because if the client has an explanation, you can put it in. And if the information, or the client, it might prompt the client to say, you know what, you're right, I forgot about this. Or if you have had that conversation over and over and over again, and your client just might have a bad memory or PTSD, or you know, just they have a lot of different incidents in their lives, and they might be prone to confusing them. That's the sort of situation where you might say, well, remember last time we talked about this, and you said that happened when you were 12, and now you're saying it happened when you were 20. Which is it? And then they just might be confused. And if the confusion persists over time, then that's a situation where you might provide fewer amounts of detail. Because especially if you fundamentally believe that what your client is saying is true, and they are having difficulty remembering when things happen and presenting information in a chronological order, that's a very common occurrence for asylum seekers, especially survivors of trauma. So that's a circumstance where you provide the information in a general way and try not to nail your client down to a timeline that is going to get them into trouble later on.
All right, so dealing with bad facts or facts that just don't necessarily fit with logic. So we have had cases in which a client firmly believed certain things that are just implausible or really contrary to what Western society believes is true. So, for example, we recently won asylum for an individual who believed that harm he had suffered and would suffer in the future was because someone had performed voodoo on him and put threats on him, and he was going to be killed as a result. And the client firmly believed this. We had another case in which a woman was forced to marry this chief in her town and believed that the chief had turned into a snake and had come into her room and raped her in the middle of the night. And she firmly believed that this had happened. So on the one hand, it's very important to explain that in the affidavit, because these are your client's beliefs, and this is why your client has a fear of return. But then how you deal with the logic of that can vary depending on the situation. If you have a savvy, educated client, you may be able to talk to your client and have him explain how, like, yes, it's true, I understand that this doesn't make a lot of sense in Western society, but I really believe this, and in my country this happens all the time, and this is what everybody believes. So you can explain it in that way. This is another area where in your legal brief, country condition documents are going to be really crucial. So for example, in that particular case with the individual who had voodoo performed on him, there was a lot of documentation from science talking about sort of the psychosomatic effects of certain religious beliefs and voodoo and threats and things like that. So that explained how somebody could really suffer actual physical harm because of their belief in voodoo and things like that. And a country condition expert could also explain how in this particular society these beliefs are really well held, and that somebody may firmly believe that an individual turned into an animal because that's what is commonly believed in their society. So those outside sources can be really crucial in this context. What if you learn facts, though, that are just harmful to your client? So you learn something that perhaps your client's brother, who was also being targeted by a gang, recently moved to another part of the country and is now not having problems anymore. Or you learn that the political party your client belonged to has now recently joined the government and is actually part of a coalition government. And so maybe your client doesn't face harm anymore. So I think the first thing you need to do, of course, is make sure that the facts you learned are actually harmful, to make sure that there's not a misunderstanding, and again, to sort of confront your client and make sure that you have a clear understanding of what happened. Then you typically are going to want to make sure that the facts are not distinguishable for your client. So if your client's brother relocated safely, is your client going to be different? So can your client not relocate for some reason that's different than his brother? Or is the fact that your client's been in the United States going to place your client in a different situation than his brother? But then fundamentally, it's going to be a question, as Karen noted earlier, of strategizing as to what do you want to present in the affidavit versus what do you want to leave for the hearing or the interview, and prepare your client to address if it comes up. Because if it's not something that is so harmful that you think you need to get ahead of in the affidavit, there may be a lot of strategic reasons why you don't want to really address those harmful facts in the affidavit, and you just want to prepare your client very well to address them should they come up during the interview or on cross-examination or examination by the judge.
And this is the kind of thing where this is a place where NIJC is really here to help you, and this is another one of those circumstances where I would strongly urge you to talk through this strategy with us, as because we are going to be able to predict with probably a greater degree of accuracy what's likely to come up in immigration court and what's going to could easily be glossed over, and also whether or not something is really harmful or it seems really bad to you, but it might not actually matter that much.
And this goes for everything that we're talking about. We hope this webinar is very useful to you, but should any of these issues arise in your case, please contact us. We have very likely dealt with them many times before. Okay, so adding polish. How much can you sort of finesse your client's affidavit so that it looks pretty and seems like a very nice document, and also, but while also keeping it accurate and true to your client's own voice? My personal perspective on this is I want the client's affidavit to be grammatically perfect. I don't even if my client does not speak in the most particularly accurate grammar like I am right now, and I also want everything to, of course, be spelled properly and all of those things. So I think that is very appropriate, and I think that judges understand that part of your role is to make sure that the document sort of conforms to those kinds of norms. That said, I don't think that you should provide a lot of flowery embellishment or elaboration on things that your client said, or if you're, especially on the topic of getting feelings in. I think that that's something that Ashley mentioned as being really important, and that's an area where it can be really tough to get a client to sort of elaborate on their own about emotion, and it can be really tempting as a lawyer to say, well, this is probably what they mean when they say I was sad, but really you need to get that from them, and so you have to press them and say, well, when you say I was sad, what do you mean? Give me an example. How would that look for you on a given day? What was your day like? So try to ask people to paint a picture rather than assuming and creating that sort of polish for yourself. And not only are there obviously some ethical considerations when you are adding additional, coaching or words to your client's statement, but at the end of the day, your client's affidavit has to match up with their testimony. And so if you include that flowery language or talk about how your client was so terrified when your client just typically says, I was scared, that's going to be a credibility issue when your client has to testify and is not using words that are keeping up with what was used in the affidavit.
Right, and along those lines, as Ashley mentioned at the beginning, you have to tell your clients what asylum is and what the elements are and what they need to prove. But when it comes time to the affidavit, you don't want them to think, well, you told me I have to prove that I was persecuted, and this is in my mind what persecution is, so I'm going to tell you this story. Because if you focus too much on the elements and sort of creating an elements-based affidavit, it's going to be totally not true potentially, and it's also going to sound like it's not the client's voice.
So that's all we have today. Do we have any questions from the web? Any questions from the room? All right, well, thank you everybody for participating today. This webinar will be recorded and will be uploaded onto our website soon. Please stay tuned for next month's webinar, which will be available on our website if you want to register.